702.
Live
on the Prime Media Plus app.
DSTV channel 856.
92.7.
And 106 FM. Let's walk the talk.
You're on 702. I'm Thabo, in for Clement. Thanks very much for joining us. It's 7 after 11. Welcome. Great having you with us on the 1st of May, which is a Workers' Day holiday. In South Africa, we are excited to have you with us. And the rights of workers are at the fore of our mind, particularly today, given that there are various dynamics working against an ordinary worker who is a backbone of a South African economy. And often we are at loggerheads, employers and employees trying to iron out things that pull us apart, and we should be working towards working together. So on this very significant day, it's lovely having you with us. We started off at 9 o'clock with an open line, and we spoke about various other issues, including South Africa having a white president, workers' rights, how much do you earn? We went on the second hour to reflect on the beautiful career and amazing times of Kawunina Kubeka, who is a businesswoman and actress, a star in South Africa. We had a lovely chat with her, and we could not even play some of her other songs that she had requested because time just flew by, and it does that when you're having fun. And in this hour, we will look at something extremely serious, especially given that the caseload in our courts is very, very high. It could be that you are a litigant right now in court and you are thinking that things are taking far longer than they should. Well, it's because the load is high. A lot of people are engaged in the courts and seeking various forms of assistance, justice, and help. In some instances, we know that some cases have been on the roll for as long as 5 to 10 years, and they are yet to be concluded. And we'll touch on that in the dialogue today. And the dialogue is a feature that Clement has every Thursday between 11 and 12 o'clock, where guests are invited to ventilate on serious issues such as this one. And today we are asking, should civil cases go through mediation before trial to reduce the caseload? And the bottleneck is too stuffed right now, so to speak. So we need other ways. And you'd remember that the Judge President of Gauteng Division of the High Court, Justin Erasmus, has issued a directive making mediation mandatory for civil cases before trial. And the directive seeks to curb the high caseload in our courts, and the Gauteng division faces a severe backlog in civil trial matters, with trial dates currently being allocated as far ahead as 2031. And you do know that we are in 2025, right? So about 6 years ahead. So the directive compels parties to attempt mediation, thereby reserving court time for matters requiring judicial adjudication. However, some legal practitioners have warned that this directive could significantly delay and be a barrier to justice, as some will exploit it and some may undermine this process. Nonetheless, I think there is a strong sense of benevolence in what the Judge President of Gauteng Division had put on the table. I'll introduce my guests in a short while, but feel free to engage with us on text messages, voice notes, and just calling and asking my guests those questions as to how this will truly work. It will have a bearing on all of us, and then we should be interested in knowing how it will work and what are the pros and cons. How do you even start? What if someone is abusing it? What if you are litigating on a civil matter against a huge corporation or a government department? Will they not exploit this method? Will they not exploit mediation? And what happens if you can't reach a conclusion at mediation, where everyone else is just steadfast and on their issues and they don't want to move at all? 011 011-883-0702. 011-883-0702. Alternatively, send a voice note or a text message to 072-702-1702.
Join us.
Let's walk the talk.
This is 702.
And Advocate Justin Erasmus is the chair of the Personal Injury Plaintiff Lawyers Association, also known as Pipla. Advocate Justin Erasmus joins us right now on the line. Thank you so much for your time, Advocate Justin. Welcome to 702.
Good morning, Thabo. Thank you for having me.
Thanks for making time, especially on a public holiday. Mbekezeli Benjamin, Research and Advocacy Officer at Judges Matter, who needs no introduction at all. He's a regular, or we should call him a co-presenter here at 702. Mbekezeli, hi, welcome.
Good morning, Thabo, and good morning to Advocate Justin and McIntosh, and happy Workers' Day to all hard workers in South Africa.
Yeah, I'm just pulling your leg. Don't take me through a civil litigation process. McIntosh Polela, spokesperson for the Road Accident Fund, is also on the line. McIntosh, great chatting to you. Welcome.
Good morning, my lord, and good morning to the panel members as well as your listeners.
Great, thank you.
Morning, McIntosh.
Yeah, now that I've established that we have all of you on a very clear line, I think let's just kick it off without any further ado. Advocate Justin, maybe let's start with you. What do you make of what the Judge President had put on the table and this directive? Do you see it as being a way forward to reducing the backlog, let alone the backlog, but does it have merit in somehow resolving various social disputes of a civil nature?
Well, Thabo, it's a very complex thing. And let me start by saying, I think there's one thing that all of us here this morning will agree on, in fact, all South Africans, is we need to do something to reduce the waiting times in our courts. If we can, later on, we can get into what the Moseneke Commission said, and there are various other mechanisms we could also look at. But specifically regarding mediation, there are two problems that arise from this directive specifically. The first one is a wider, more principled problem. Judge Mlambo has issued a directive which is essentially unlawful. He's making a law which he cannot do by means of a practice directive. The directive clashes specifically with Rule 41A, which says mediation is voluntary. You can't, in our hierarchy of laws through a directive, make a law. There are two applications, currently urgent applications pending before the Concourt to deal with that issue, and we'll hear what the Concourt says about that. So I'd prefer to move on to away from whether it's lawful and what he's done is lawful or not. I'll come back to it if you want me to, but there's what we say is the bigger issue is the way that this directive will be implemented. You must understand that the numbers are staggering. In the second half of this year, for example, there's probably about 8,000 matters on the roll in North and South Gauteng together. Those people are all plaintiffs that have been waiting for years to get that trial date. Most of them have been waiting since about 2021. They are going to lose those trial dates without a shadow of a doubt. Mm-hmm. The directive says if you don't mediate and have a certificate of outcome, and remember, a mediation process takes about a month and a half in terms of the directive. If you don't have a certificate of outcome lodged 7 days prior to your trial date, you will lose that trial date. You won't even get into court. Now we sit with a situation where plaintiffs are adapting to, I beg your pardon, to a new system. The Road Accident Fund, and my heart goes out to the Road Accident Fund because they've really been placed in an impossible situation here. They have to create internal structures within their organization, and Mr. Polela can tell us about this. Internal structures within their organization. They've got to staff those internal structures. They've got to integrate those structures with their existing systems, and then they've got to start wading through all of these demands to mediate. I know of about 8,000 or 9,000 that have been served just for the next few months. I'm aware of responses because I get feedback from our members of 1 or 2 responses from the Road Accident Fund saying they declined to mediate. But those are special cases where there's a clash with the board notice, and it's a foreigner's claim. Again, McIntosh can perhaps talk to that if he wishes to. But there's not been a single case where they've said we are ready to mediate on this matter. Not a single case. Might be somewhere outside of our members, but of the thousands I have access to, there's not been one.
Sure.
If you have a term starts on 22 July, we have no time. People who are going to lose their trial dates, and we say that it's a terrible infringement upon a victim of a road accident fund who's been waiting for years for his trial date.
And we'll come to McIntosh momentarily. But first, Mbekezeli, Benjamin, let's come to you. As people who are really consumed in the justice system and as an element of the ecosystem of our justice system that is truly interested in advocacy, to what extent does this lift or seek to lift the pressure over a court system that is heavily burdened? And is it your impression that this will positively augur with the spirit of speeding up justice?
Well, Thabo, I'd like to echo a few points that Advocate Justin made, which is that the main aim of the justice system or the judiciary is to make sure that people get justice as quickly as possible. If a case needs to be resolved through a court process, it should happen as quickly as possible. You can't wait many years for you to come in front of a judge. Now, the situation that we're facing currently is that we just don't have enough judges. We don't have enough courts for the kind of population that we have and the kind of litigation that happens, particularly in Gauteng. I mean, since 2009, in Pretoria and Johannesburg, we've only had about 82 judges. So more than 15 years later, we still have the same number of judges. And if you look at the population of Gauteng, in 2009, it was 10 million people. In 2025, it is almost 16 million people. And that population is still served by the exact same number of judges. And so the system is under humongous pressure. We know that even the budget allocation to the judiciary has been declining for a number of years. There was a small bump last year, but it hardly is fixing the problem. So fundamentally, we need more resources allocated to the judiciary. So that's the first point. Secondly, we need to, we need to utilize the resources that we have efficiently. And this is how we see this mediation directive. It is certainly not the silver bullet to solve the problem, but what it intends really is to try and sort of be a bandage to essentially a gunshot wound. And what the attempt is to do is to try and weed out some of the cases to ensure that only those cases that really do need to come before a judge are resolved before a judge. How that is done, I think, is where the huge controversy is. And there are questions about the Judge President's directive being legal or not. And there are real questions about what prejudice it will have on people who have been waiting in court as plaintiffs and those who still have trial days coming up. But the main issue really is that we need more resources allocated to the judiciary, and the resources that we have, we need to find a much more efficient way of using them.
Before we go on to McIntosh Polela and Mbekezeli, what do you make of the resources being injected into the mediators as anticipated by Judge President in Gauteng? Because that would simply mean that load will continue to be in the queue if we do not get more mediators, more resources, and of course facilities to reduce that particular backlog. Isn't it counterproductive?
Look, mediation, I think, as a practice is good. I mean, in most jurisdictions around the world. So mediation is the go-to. I mean, in the US, almost 90% of all cases are mediated and only a few go to trial because they have very complex jury trials. And so mediation as a practice is not bad. The main concern really in South Africa and with this directive is that mediation will sort of require additional expenditure.
Yes.
So people who have their cases in court, they have to now pay extra to go to a private mediator for them to before they even come before a judge. So that is the concern, because now people who have already been waiting, like Advocate Justin says, have been waiting for 2 years, now have to go through an additional process that costs them more money for them to come before a judge. So that, I think, is the concern, even though on principle it does seem that mediation may assist in sort of trying to resolve some of the cases. It certainly won't deal with all of the cases, but it will go some way in resolving them. The only issue, I think, is the cost, and I think just the additional step. But also, what the Judge President said in his statement on releasing the directive was to say a lot of the cases are settled. He said 80% of the cases are settled on the first day of the trial. And then that means that there needs to be a conversation about why that is happening. And I read from one of the court papers is that the RAF has a policy that it can only begin settlement discussions only when you have a trial date in hand. And maybe that is a conversation that would help. I'd love for Mr. Polela to clarify that issue, because that, I think, is the key question that needs to be asked. Is it efficient for people to first go through the court process, get a trial date before they can even begin this process of settlement discussion with the Road Accident Fund?
And he'll jump into that in a short while. But first, McIntosh, you've been listening very carefully and closely to your two other interlocutors. I'm interested in finding out from you as ref. I don't want to call you guys culprits, but I would want to call you the significant contributors in various civil cases in South Africa. Does this directive come as a much needed relief to you?
Good morning again. We, right off the bat, when the announcement was made by the Honourable Judge, welcomed the intervention. However, there are pros and cons in this. As my honourable friends have mentioned, there are hoops that one has to go through. Mr. Benjamin took the words out of my mouth by saying that 80% or more of our cases, when it comes to the Road Accident Fund, are done through a settlement. That settlement is done at the steps of the court before you even see a judge. And then you ask yourself, why were they not done in the first place? But that mediation or that settlement comes after years of the two parties going back and forth. I have in my emails since the announcement was made, and I do get copied by some of the lawyers, an interest in entering into some kind of mediation and a settlement. So you can see that there's an appetite with the lawyers, but as Advocate Erasmus has mentioned, there are a lot of difficulties when one looks or zeroes into the details. And so it's not a silver bullet. And I think I heard one of the panel members mentioning it. We welcomed it, and we still do welcome it. However, I need to correct something. Look, we do welcome discussions about settlements even before the cases are. We get a trial date. The difficulties that we have is, I think we need to get the two parties, both the RAF and the lawyers, to do better when it comes to the discussions. Advocate Erasmus correctly mentioned that the staffing of the Road Accident Fund doesn't allow enough cases to be settled before the court. So there's a lot of work that would have to be done for the intervention by the Honourable Judge President to be able to succeed. But on the whole, we do, accept the mediation, and we do. Let me mention that we do feel sorry for the people that have closed dates, that they were hoping that these dates are finally going to bring finality to their cases after waiting for, in some cases, many years. And that is where it's going to be problematic. But where we stand on the whole, we do welcome the intervention.
Perhaps before we dispense of this issue, McIntosh, Mr. Benjamin alluded, as you have touched on it slightly, the matter of the trial date being important or significant. Is it mandatory for you as RAF prior to the commencement of the mediation effort?
Look, if a lawyer, if Advocate Erasmus has a client that off the bat wants to enter into settlement negotiations or by way of mediation, I mean, there's no way that we would say no to that. I mean, there are a lot of lawyers, as I said in my inbox, that have said we want to enter into a process of mediation or settlement negotiations. It happens all the time. We wouldn't say no to it.
Okay. It's 27 minutes after 11 o'clock. Thanks very much for joining us. You're on 702 there. This is Thabo in for Clement. We're on the dialogue and we are asking, should civil cases go through mediation before trial to reduce the caseload of various courts? And this is all on the backdrop of Judge President Justin Mlambo of Gauteng Division, who has issued a directive making mediation mandatory for civil cases before trial. We have various issues of disputes in society. You could be in a civil issue with someone and you've been waiting for a date of trial. It's taking far long due to the backlog that the courts are experiencing. Mbekezeli Benjamin alluded to the fact that, amongst others, we do not have a great number of judges. We do not have courts to facilitate these, or at least sufficient courts to facilitate those dispute resolution mechanisms through the judiciary. And I'm wondering, how long have you been waiting for? And would you welcome the fact that mediation directive is now on top of the table? Is it something that you would consider, or would you still prefer or insist on going before a judge on such matters? I would love to hear from you. And what has your experience been? 011-883-0702. 011-883-0702. Alternatively, you can call us and engage my guests on 011-883-0702, alternatively 072-702-1702. And just to recap, my guests, Advocate Justin Erasmus, who's the chair of Personal Injury Plaintiff Lawyers Association, Mbekezeli Benjamin, Research and Advocacy Officer at Judges Matter, and McIntosh Polela, spokesperson for the Road Accident Fund, which also contributes largely to the backlog and not through any of your fault, I would like to assume, McIntosh. I will be engaging some of the messages that we are receiving right now, but first I do need to take the Eyewitness News headlines, but maybe, gentlemen, just to give you a sense of the questions that we are getting, let me just read one or two. The first says, good morning. I think that every lawyer involved, past and present, in the RAF should be investigated. There is, in many cases, a very corrupt connection. This comes from Anonymous. The judge president claims there is a settlement rate of 85%. Do they have stats and date to support this? The OCJ denied a prior request to provide the profession with this data on 29 April 2025 as we deny this settlement rate. It is more likely 10 to 15% are settled. We'll get to those questions and maybe reflecting on those, gentlemen, in a short while. But for now, it's exactly 11:30.
Let's walk the talk.
702.
Thabo in for Clement, 24 minutes to 12 o'clock. And this is 702. Thanks for joining us. On the dialogue today, we're asking, should civil cases go through mediation before trial to reduce caseloads? As you would know, the Judge President of Gauteng Division of the High Court, Justin Mlambo, issued a directive to that effect, making it mandatory for civil cases to go through mediation before trial. That's been challenged, as we've heard from my esteemed guests, and we continue where we left off. 011-883-0702. 011-883-0702. Advocate Justin Erasmus, maybe let's come to you. I read out a text message that came through earlier on, and the listener was bemoaning the fact that actually the stats may not actually be accurate of mediation that has worked 85% of the time, and they are estimating it to be at 10 to 15%. As far as data is concerned, what has been your experience? And I'm not expecting you to have it off the cuff of your hand right now, but what has been your just general estimate about how effective mediation is before trial?
Well, look, Thabo, what they're referring to, they are not mediated matters. Those are matters that have settled between the parties at court. There's been no mediation up to now. So there's that 85% that Judge Mlambo is talking about is saying
Sure.
Currently 85% of matters are settling at court. We don't know. We're astounded by those figures. Pipla did a survey amongst its members, and we come to an amount of approximately 20% of matters settle on the steps of court. The Gauteng Attorneys Association did a survey. They come to a similar number. Because of the discrepancy between our surveys and what Judge Mlambo is saying, a fairly prominent firm of attorneys in Pretoria did a PIA request, a promotion of access to information request. Asked them, please, can you give us the underlying stats which tell us why you say 85% are settling on the steps of court? And the judiciary refused. They just said simply, we're not giving it to you. So that decision is being appealed. When the appeal should be successful in the end of the day, we will see why they say that. But we say that 85% is wrong. Sure. It doesn't accord with our statistics. And we've asked them why they say it's 85%, and we were just told, well, we're not telling you.
Nick Hazley is asking Mbekezeli Benjamin, and let me just be true to his words by quoting his text verbatim. If a litigant does not respond to the request for mediation, the judge president has told the profession to compel them to respond and attend to it. Is this legal? Can they be compelled? And he goes on further to ask that the defense will be struck if they don't respond to the compulsion. Does this not open up legal certainty to severe uncertainty as it gives ample opportunity for appeals? The striking of a defense would be illegal and against rules. Mbekezeli?
Look, I think Advocate Justin will probably have a better sense of the practicalities of it, but there is a mechanism to force or to compel a party to go into mediation. And I think this may be where the directive would clash with the rules, because Rule 41A of the Uniform Rules of Court do make mediation sort of voluntary, and the directive makes it compulsory. So then the question is, which do you follow? Do you follow the rules or the directive? Because ordinarily the rules supersede the directive. And so there are legal questions that need to be asked about whether that is actually possible. Can you compel someone? And if they don't, is it lawful for your defense to be struck off? So the question, the short answer is that I don't know, but the longer answer is that there are open legal questions about that.
Great. And McIntosh Polela, I'm not sure if this is for you. Maybe this listener will clarify it once I've read out the question, but I think it was directed your way. And as it reads, my cousin has been waiting for 13 years. He did everything with a lawyer. He doesn't want to do anything with a lawyer now. Looked for help with LPS in Mainland. It's a tear now. There has been any response now. I'm reading it as it is. There hasn't been any response now. What to do? Please advise. In your instance, McIntosh, when someone has been irritated and perhaps frustrated by the legal representative on the issue, what happens?
So on this specific case, I think what I would do is to encourage them to call our contact center, so that we can deal with the specificity of this matter. And our number is 087-820-1111. Then we can look into the case and what has happened, and we can try and assist. But in the instance where somebody has been irritated by a lawyer, and it happens, all the time, that there is a clash between the attorney and the client, and it has happened that somebody, for instance, had submitted in 2019, and they felt that the case was going nowhere, and they came directly to us after that, and they received a settlement of 800,000. But what happens from that is, you must remember that when you give your case to a lawyer or an advocate, you sign a power of attorney, and they deal with that case, and they bill for that case. And in the instance of this individual who received 800,000, that he then received and a call from the lawyer, where the lawyer was saying, I represented you and you owe me this much, and there was a clash between the two. So one has to caution in that instance, but I do confirm that it does happen from time to time. But again, in the specific with the specific listener who has approached you, I do encourage them to call us again on 0878201111, and we can deal with this case.
And we'll try to repeat the number towards the end of this interview. It's just something similar, McIntosh. Perhaps you may have just a one-word response, or say, Thabo, I've just given you the number. Just to do justice to it, it says 2018 accident happened, 2030 court date. Maybe Advocate Erasmus, this is a bit frustrating. How do you reconcile, perhaps legally, the matter of mediation and speeding up the trials? And you have been extremely eloquent and articulate on how the judge president cannot just issue this directive based on its lack of legal soundness, if you will. But something needs to be done. What are some of the issues or interventions that can be entered into to mitigate against what some of the listeners are saying? 2018 accident happened, 2030 court date.
Thabo, there's a number of things that can be done. Firstly, the government, the Minister of Justice, needs to take a good hard look at the report of the Moseneke Commission, which is something that Mr. Benjamin touched on earlier. We just don't have enough judges. That's the elephant in the room. If we had enough judges, we wouldn't be sitting here having this conversation today. A good hard look needs to. We probably need another 30 judges in this division, would be my guess. So that's the first thing. The second thing that needs to be looked at is, I don't think we should abandon mediation as a vehicle, but it needs to be implemented more carefully. And there's two legs of things that we need to look at here. The judges have ignored the fact that the South African Law Reform Commission has a discussion paper and a draft bill out. I believe discussions and comment ended on that on the 31st of April, yesterday. So there's a policy framework. If you're going to introduce mediation, you must do it in terms of a law, because at the moment we have these clashing imperatives between the directive and between the law. If you're going to introduce mediation, do the law. The South African Law Reform Commission is grappling with things, for example, about who pays. Should the state pay, as happens in the labour courts? Those kind of issues have got a far more nuanced and more, how shall I put it, not a softer approach, but a wider and more considered approach than the directive. And we think the directive should have waited and been integrated with what the South African Law Reform Commission says. On the very immediate level, there are things that we can do, matters that can get mediated and or settled. Mr. Polela will tell you there were block settlements, which were, unfortunately, they weren't continued with after a certain point, but they were quite effective in dealing with a lot of cases fairly easily. We could identify, for example, simple merits cases where there's a passenger involved. We could identify loss of support claims, which are generally fairly uncontroversial. There's a number of categories of claims that could be introduced either and used and sent to block settlement, or perhaps put into a mediation stream that is voluntary. And I'm telling you, plaintiffs' attorneys would love to deal with those kind of matters quickly and easily. That would have several advantages. That would immediately start reducing the number of matters on the roll, and it would also give us a proof of concept for whether mediation works. But Unfortunately, none of those measures have been looked at. We haven't looked at what the Law Reform Commission says. We haven't looked at a pilot project. We haven't looked at prioritizing categories of cases, and nothing has been said about the elephant in the room, the Moseneke Commission, and our drastic shortage of judges in this division.
Candace writes to us and says mediation is 25,000 rands a day. That sounds like an exorbitant cost, and someone perhaps will still argue that going in front of a judge will be more expensive. Mbekezeli?
Look, I think it ranges on a number of factors, the experience of the mediator, the complexity of the issues. So it really depends on what would be the best for each particular case. But many of the proposals that Advocate Erasmus just raised now on identifying worthy cases that are suitable for mediation, where the dispute really is very, very narrow, and it doesn't actually need the use of a judge in resolving that dispute. I think that is something that should be explored in more cases than we currently are doing. But there's also, I think, a bigger question of how do we ensure that people still get justice as quickly as possible, because part of what the Judge President put forward as a motivating factor for this is that, yes, people may have trial dates in 2030, but if you waited between now and 2030, a lot may happen. People may actually die. Some people will lose their evidence and all other issues between now and then. So there maybe is a lot of impetus to get some of these mediation discussions or settlement discussions going so that some of those cases are resolved sooner than later. Because at the end, if you wait 3 years and you get a very small amount at the end of it, was it really worth the wait and the cost of it? So I think that's a bigger question. But also, the Minister of Justice certainly does need to be part of this conversation. And the Moseneke report actually has made some recommendations on the need for more judges, the need for more resources in the court system. And we still need to hear from the minister on why between June 2024, when the report was released, up till now, we haven't heard anything on what is the plan. What will be done to ensure that we get more judges in Gauteng and probably across the country? It's not just a Gauteng problem. The epicenter of the crisis is in Gauteng because more than 50% of all civil cases in South Africa are dealt with between Johannesburg and Pretoria High Courts.
0727021702. Feel free to send your voice notes to that number. Mr. Polela, how does your mediation work, or perhaps settlement agreements work? Do they involve a third neutral party that comes in to bring the two parties together, or do you do it internally? How does it really work at the Road Accident Fund?
No, it doesn't. It doesn't include a third party. As I said, we do have inboxes of lawyers who are voluntarily coming to us and say they want to enter into settlements. In fact, I was listening to Advocate Erasmus when he was talking about block settlements. Last year, we were approached by the Black Lawyers Association, the BLF, and in some of the discussions that we had several meetings. It was agreed between us that the cases that are ready for settlement should be brought forth, so that we alleviate, the stress on the courts. And we here and now, I offer the same invitation to Advocate Erasmus to say, perhaps, as an association, as with their colleague, we should have meetings where these cases can be settled. And unfortunately, where we meet Mr. Erasmus's, Advocate Erasmus's colleagues, it's mostly at the courts where we have disputes, or in the media when we're having ping pong fights between each other. And I think what this calls for is for us to, sit around the table more and find, cases that are ready to settle, and try to settle them as quickly as possible. As it stands now, with Advocate Erasmus's colleagues, he mentioned a firm in Pretoria. We have a very adversarial relationship which is not good for for the justice system. It's not good. It's not good for ourselves. It's not good for the relationship between ourselves and Mr. Erasmus's colleagues. Going forth, I think we need to, both from ourselves, humble ourselves and say, look, in the interest of the clients, let's sit down and let's find out which mechanisms we can use to try and find each other in the interests of clients. And my cell number is open to Mr. Erasmus. Let's talk. Let's talk about this to find which cases we can settle sooner.
Yeah, and I'm not going to charge you 25,000 rands a day for me putting the three of you together and talking about it.
We'll talk, McIntosh. Thanks for the invitation.
Yeah, and I think it's very much a sense of sobriety that comes into this, because it's for the benefit of every South African, if you could. But Mbekezeli, let's come to you. I mean, you are always fighting very hard for people to understand how the judiciary works, but also to highlight the plight and challenges faced by the judiciary. In this instance, the numbers are staggering. I mean, I'm just getting people sending various dates here. Someone is also saying 12 years of waiting, and yes, a lot can happen in that time. Maybe draw a picture for us, if you can, just to sober us a little bit, Mbekezeli, about the state that we are in right now. What will happen if this directive is challenged successfully in court and we are back at square one? The caseload, the backlogs, and the long waiting periods. What does it mean for an ordinary person who is in the queue right now, but also for the judges? And not just their mental health, but the workload that they have to face and the quality of judgments that they have to issue.
So we are in a very difficult situation, Thabo. I must tell you. I think for people who are waiting in court, and to be quite honest, the directive affects mainly people waiting on the civil trial road, and it affects mainly people with road accident claims, medical negligence claims, police misconduct or unlawful arrest claims, and even those who have business or general damages claims. So people who want to sue to recover money. Those are the people who are mostly affected by this. What it essentially means is that you just have to wait in queue. You have to wait in line, and you get a trial date in 2031, as you mentioned. And between now and then, that means if you were injured in a road accident, that means you sit with those injuries for a good 5 years, and you either will continue to live a very difficult life, you will sometimes not have access to the medical assistance that you need in order for you to get better. Some people will lose the evidence that they need to prove their claims. Others, like I said, will die. For those similar with those who have medical negligence claims, I think that is really the difficulty with them waiting so long. And so these interventions are needed, and they were needed yesterday. And I said the first priority is for us to get more judges and to get the Palm Ridge High Court, for example, a fully fledged High Court division there that will relieve some of the pressure on the courts. For judges, what I've heard speaking to judges in both Johannesburg, Pretoria, and other courts is that, look, the workload has become impossible. You really hardly have any time to read and prepare. You work over weekends, over public holidays. You really are under a huge amount of pressure. And unfortunately, we see the effects of this in the long delays between when the hearing happens and the judgment comes out. So people wait 2-3 years, not years, but the norms and standards say that you have to get your judgment within 3 months. That 3 months is actually the exception. Most judgments take longer. And not that the judges are not working hard. Our judges, the vast majority of them work extremely hard,
sure,
like I said, over weekends and public holidays to get the work done. But that comes at a cost to their mental health. And unfortunately comes at the cost of the quality of justice that we should receive. And so we do need these interventions as in yesterday.
Very quickly, gentlemen, you'll have 20 seconds each to respond to Stembiso, who's calling from Centurion. Stembiso, keep it short, please. It's your turn.
a very important conversation. You know, I'm one of those who feel compulsory mediation really, it fringes upon right of litigant to access court and to justice. I don't understand why mediation has to be compulsory. Let me tell you this. Before lawyers take matters to court, they would have tried. And what they would have tried to settle the matters. But what happens, people only settle when they see that the date to go to court is approaching, which forces them to then settle matters. It's not that people just, there's no lawyer who can take a matter and then say, I'm going to court just because I want to go to court.
Sure. Stemmy, so let's leave it at that. I think we got the gist of it. Sorry, you called at the tail end of the show, so apologies to rudely cut you off there. Gentlemen, about 10 seconds each in closing, starting with Advocate Justin Erasmus.
Compulsory mediation does infringe upon the rights of litigants. I agree with the caller. We do think that mediation in general, as a voluntary mediation, perhaps incentivized by early trial dates or something like that, could assist, but we don't think that people should be barred from court by costs or time of mediation.
McIntosh Polela, briefly.
Look, we do welcome this, as I said earlier, but again, it needs to be looked into much further. I just want to once again say to Advocate Erasmus, we need to fight less and talk more.
I agree, McIntosh.
Mbekezeli Benjamin, 10 seconds.
No, I think, this is a longer conversation, but we do need the government to step up, and both the Minister of Justice and the Minister of Transport, in terms of capacitating the RAF to deal with some of these claims and settle them early, is something that also needs to happen.
Thanks for your time, gentlemen. 2 minutes to 12 o'clock.